you talked about estate planning, and what you'd find are voluminous, multi-thousand page leather-bound books talking about very intricate strategies to avoid the estate tax. Well, back then, the estate tax was $1 million. Now it's $11.7 million. The estate tax really isn't a concern for most of our clients, given the level of wealth that you have to have it impact you. Now, what is a concern is all the other universal aspects of estate planning that are extremely important to protect families. And these are the conversations that lead down to life insurance conversations and any other financial planning conversation when you get down to it, because it's all encompassing. But I know I'll talk fast and we'll cover a lot of material. So it's always nice to know where to go to get the collateral and to look back and digest some of it. And we'll have some of this available to you. A couple of resources. One is transamericaadvancedmarkets.com. Really easy website to remember. So you just go to www.transamericaadvancedmarkets.com. A lot of our client-facing collateral will be on that site. Also has additional information on the Advanced Markets Group. We also have, and I think this is extremely important, it's a tandem piece to this presentation. One of the things that's always driven me crazy about estate planning is there isn't one go-to source when you have an estate planning question. You can't go to estateplanning.com and pull up an encyclopedia of estate planning. So you have to cobble it all together or know where to go to get all the answers. Part of this program is we put together a comprehensive piece called the Field Guide to Estate Planning. It is a reference tool and it cuts out a lot of the extraneous information. So what we find is when people use it, they find information very quickly, and it's the most important information that they're going to get from a reference standpoint. So we have that available as a PDF. It's also client approved. So I know a lot of times you go to these presentations and communicating this back to clients can be a little bit difficult. So this piece is something that you can share. This presentation itself, though, is, as you can see at the bottom, for financial professionals. We have another presentation, which is the diet version of this presentation. Because of all the information that we have included in this program, it's a lot to throw at someone who's a client. So we have another version that is a client-facing presentation that goes over all of the applicable sections just in a little less informative standing, because this is an educational presentation. This is really to get across the importance of estate planning. And then I'll talk about some other topical pieces that we have available for estate planning as I gravitate through the different areas of estate planning that we'll discuss. But one of the things that's interesting when I talk to financial advisors is some of them almost poo-poo estate planning. They say, it's not important to me. I'm not an estate planner. I'm not an attorney. I don't really address it at all with my clients. I think that's missing the boat. You look at estate planning and you look at what clients are looking for from their financial advisor. This is an area that they absolutely need help with, and they're looking for expertise around. Also, I would say it's impossible to work in the financial services arena and not talk about estate planning. Every time that you fill out an ownership line on an account statement, anytime you fill out a beneficiary designation, you are, whether you want to admit it or not, doing estate planning. Understanding the significance of what you put in those lines and how it's going to impact the individual client and their family are essential elements of what we do on a fundamental level. Also, I think if you're not addressing it or you're not taking credit for it because you're doing it anyway, you're really missing the boat and an opportunity to demonstrate the value that you bring to the table to the client, but also to their family. So retention is a big part of this. One of the issues that we hear about a lot from financial advisors is when a client passes away, they have a hard time building a bridge to the next generation. And a lot of it is because they haven't taken the time to build credibility and value to what they bring to the table for those beneficiaries. And you can read a lot of statistics on this. I've read several of them, and most of them are not friendly to the job that the industry as a whole has been doing. The most friendly one I saw was from T. Rowe Price, and they said 78% of the time the beneficiary leaves the initial financial advisor after the death of the original client. There's also a statistic that talks about widows, and they say 70% of widows fire the financial advisor within 1 year from their husband's death. So the retention rate is not all that great. And unfortunately, those are the friendly statistics. I've read plenty that say that it's close to 90% and above. So again, estate planning is a big part of that. If we're not demonstrating our value to our clients' beneficiaries and how we helped them through the financial planning process, why would they ever want to retain that advisor as their own? Also, it's not just something that occurs at death. This is something that's important throughout the lifespan of a client. Incapacity planning often is a blind spot in many people's financial plans. This is an integral part of estate planning where you can demonstrate your value and create those connections very quickly if you know how to do it properly. And then our clients expect it. Our clients expect more now than they ever have. You can make claims about investing and how the investment world is becoming more and more commoditized. Estate planning isn't commoditized. This is a service that requires advice and needs a deeper understanding of the client at a very relationship level. If you don't have that deeper connection with the client, that's where you do become commoditized, and that's where you lose the connection that lasts to retention for the client and their beneficiaries. So when it comes to estate planning, we really advocate just a very basic approach. And I think overall, and many people would agree with this, keeping it simple is essential. You can listen to a lot of estate planning presentations, and 90% of it, I've sat in the audience and it's gone over my head. And that's because it's not simple. It becomes overly complicated. If it's overly complicated, is your client really going to be able to understand it to a level that they're going to be able to put it into practice? So when we're addressing estate planning issues, it has to be something that they can understand and something they can execute upon, or else it's really just wasted time. And I think part of that is doing it incrementally. If you can do this over time and introduce important aspects throughout the life phases of the client at different points in time, it's much easier to put those into place instead of trying to do everything all at once, which tends to be one of the things we see people try and do. And then, of course, this is an area where it's a lasting connection point to clients. It's something that needs to be monitored. Things change. This year, there's a lot of change. There's vaccines, there's quarantines, there's stimulus, there's changes in regulation, and there's changes in taxes. And with those changes needs adjustments. And with those adjustments come opportunities for financial professionals to better the lives of their clients and their families. And that's really where I think there's a massive opportunity this year. If you can identify just a couple of different things, I think there are a large amount of assets to be gathered and sales to be made because people are going to need these remedies in their financial plan going forward. So we'll talk about those as we move through the presentation. But our road plan for today, and again, we're going to try and keep it very simple. There's a ton of information in this presentation. So again, if there's any questions whatsoever, our group is always here as a resource to help you. The collateral can help as well. But we're going to focus on the areas that really are most important to clients. And I look at estate planning kind of like an onion. It has layers. Everyone has a fundamental need for certain aspects of it, like transferring wealth. That's a very essential part of the estate planning process. It's also very situational. And this is where the expertise is required to address it specifically for clients that have different situations. So understanding there are additional needs for certain clients around controlling how their assets pass will be something we'll talk about. And then finally, high net worth clients and changes in our regulatory and tax landscape that are impacting estate planning, which are opportunities for us to have new conversations with clients and address some of the things that they've already put into place. So we'll start with the universal requirement of estate planning, which is transferring wealth. And this has been the focal point of the estate planning industry really for the last 20 years. And it's because the estate tax exclusion has made it so most people don't have to worry about estate taxes, but they do have to worry about actually passing their assets from one generation down to the next. And this is where we see people have a lot of issues. It's replete with problems. As this occurs, there's potential for fees, there's potential for additional income taxation if it's done improperly, delays, and then the worst case scenario is the chaos of coming with a botched estate plan that can really rip families apart because of things like lack of communication, not having a plan from the get-go, and those are very emotional conversations and can be something that can, again, rip entire families apart. But in order to understand this aspect, you have to understand how assets actually transfer. So there's several ways that they transfer. The biggest one that is a major focal point of estate planning is probate. Probate is the process of how your assets pass to the next generation via your will. So this is accomplished through courts. So more or less, there's a process where you pass away, they gather your assets or they identify them, and then they look at your will to determine how they're going to pass. And people will spend thousands of dollars on estate planning, setting up sometimes even elaborate trusts to avoid this issue. And the reason that they avoid it is it comes with some definitive pitfalls. This acronym is a really good acronym to remember why you would want to avoid probate. DEAD, dead. Very appropriate when we talk about estate planning. You don't want to kill your estate plan. And probate will do that because it results in delays, expenses, access to creditors, and disinheritance. So to understand this, think about this again. This is a court proceeding. Court proceedings, they don't happen overnight. It takes a while to allow everyone to step forward, for them to look at your will as the prime document, and then direct how those assets should flow after you pass away. So if you look at delays, there is variance across the country on how long probate actually lasts. I know across the country on average, I've read 6 months is about how long you're going to wait to get assets out of probate. But I've also read that it's not uncommon for 24 months to be the average length. So you're looking at roughly a period of 6 months to 24 months, depending on where you actually reside. Now that can vary. Sometimes it's shorter than that. Sometimes it's longer than that, depending on how complicated the estate is. And that bleeds in right to the expense level. Very simple estates may not cost all that much to settle. Large estates, on the other hand, you're going to have a lot larger expenses for probate because judges, attorneys, they don't work for free. Also, there's a level of uncertainty. You look at celebrities, and I think they're good examples of how not to do your estate plan in certain circumstances. One I'll look at is Prince. So Prince, he passed away and he had an estate roughly $300 million. Sadly, he didn't have a will. He did not even have a will. So that meant when it went to passing his estate, they lost 40% in estate taxes. They lost 16% for the Minnesota state wealth tax. And then also, we have no idea who stepped forward to make claim to those properties. Anyone has the opportunity when you go through probate to step in and say that they're the rightful heir. So it injects a level of uncertainty that's unnecessary in any estate plan. I think another good example here is James Gandolfini. James Gandolfini, he actually had a will, but he subjected his $70 million estate to probate. A lot of his estate was lost needlessly because of the lack of planning. But here also, he didn't have a lot of coordination between his estate plan and the rest of his estate planning directives as it was put forth in his will. And that all equates to potential disinheritance. So a good acronym to remember the disadvantages of probate is just dead. Also, we talk about the will, and most people, surprisingly, don't have a will. 60% of Americans to this date do not have a last will and testament. Now, I'm not saying everyone on this call should be like an estate planning attorney and need to understand how wills are composed and the nitty-gritty of it, but certainly making sure that it's up to date and that clients have given it some consideration, but also that it looks like the rest of your estate planning directives. And that's where James Gandolfini really ran afoul, is because he subjected his wife and his daughter to additional issues because of the bulk of the estate passing through the will. Other side of his equation was $7 million going to his son, which didn't pass through his will, but his will and his life insurance trust looked nothing alike. In those circumstances, your will and your other estate planning directives, beneficiary designations, ownership, trusts, there should be some continuity as far as how those assets flow, and that streamlines the process and makes it a lot better. So identifying those assets that don't pass through will is an important part of the process to make sure everything passes properly. An example of this is just ownership. Ownership will dictate and supersede a will. Many of our clients probably own assets jointly. They may not understand the significance of owning those assets jointly, but just joint ownership in and of itself is a poor man's way to avoid probate. So you look at something like joint tenants with rights of survivorship. Joint tenants with rights of survivorship is very straightforward. You often see a husband and you see a wife. They own the assets jointly. Husband passes away. It goes directly to the wife by operation of law. No probate whatsoever. It passes immediately. A very convenient construct and estate planning vehicle just by the ownership itself. However, our clients may not own their assets with rights of survivorship. There's other types of joint ownership which may involve probate. The one I'll point to on the screen is the third one down, tenants in common. Sometimes people will think that that works just like joint owners with rights of survivorship, and it doesn't. Instead, in that circumstance, if you had a husband and a wife and maybe a kid owning it, so concurrent ownership between three people, one of them passes away, it actually passes for their particular share down through their will, subjecting it to probate. So just understanding the nuances of ownership is extremely important, and even taking it a level beyond this. And this is where it starts to get really complicated. It's not just how wealth transfers. It's also the tax implications of how wealth transfers. And there are different laws in different states, and you might have clients across the country that may be in these states. So an example here of how this can vary, community property laws. When you talk about joint ownership, there's income tax ramifications at death for different types of properties, and different rules govern them. But one that we see a lot is highly appreciated stock. You might have highly appreciated stock in a non-community property state. So let's use an example here. Let's say it's jointly owned, rights of survivorship, husband and a wife. They bought the stock portfolio for $100,000. It accumulates through the years. It's now worth $200,000. Husband passes away. It's joint tenants with rights of survivorship, so everything goes to the spouse. But again, it's dynamic. It's not just the way it transfers. It's also the income tax ramification. What happens to that $100,000 of capital gains? In this scenario, since they're not in a community property state, that entire portfolio is not passing through the husband's estate, so it's not allowed a full step up in cost basis. In this circumstance, they only get 50% for the step up in cost basis. So the wife will now have a $200,000 stock portfolio with a $150,000 cost basis. Now you contrast this to either if they owned it singly or if they owned it in a community property state, you would have been allowed a full step up in cost basis. So she would now have a $200,000 stock portfolio with a $200,000 cost basis. She can walk away from that free and clear. So it's just an example of how you have to look at the actual situation, understand the intent of the client and the dynamics involved, and make the appropriate solution for them. Oftentimes in those scenarios, what we see is the husband's a lot older, or maybe even in poor health, than the wife. As long as there's a trusting relationship, it may not be a bad idea for the husband just to own that asset outright, so that when he passes away, it goes to the spouse and she gets a full step up in cost basis. But there's different trade-offs that have to be considered in the estate planning equation, and that's just a good example of it. Another one that we run across a lot, and I'm sure everyone on the phone here is an expert at beneficiary designations, but this is an area where our clients aren't. They make mistakes, and these mistakes are extremely costly, resulting in all of those things that we talked about, like disinheritance and additional taxes and fees and expenses. But beneficiary designations, when filled out properly, just by naming someone individually as opposed to passing it through the estate, will bypass probate. So there's a definitive advantage to beneficiary designations. But depending on the type of account that you have, there is a multitude of different rules that you have to consider. So things like qualified plans, IRAs, and annuities, those are tax-deferred investments. Even something like a Roth IRA is constrained by additional rules, and you have to understand the ramifications of the types of beneficiaries that you list. Life insurance is very straightforward and easy because it is income tax-free. So as long as you're not passing it through the estate and needlessly subjecting it to probate, it's one of the easier ones to fill out. TOD, POD, those are just types of accounts that don't generally have a beneficiary designation. So take an example as your checking account. When you open a checking account, they're not handing you a beneficiary designation. There isn't something attached to it, but you can ask for a POD or a TOD for a checking account or a brokerage account to have an otherwise beneficiary designation to help avoid probate. But having expertise in this area and knowing what to look out for and some of the issues that clients run across, because according to Ed Slott, 80% of beneficiary designations have errors. And in my career, some of the toughest cases that we've run across where we've seen large chunks of accounts lost are due to simple beneficiary designation errors. And these are very easy to spot and overcome. I would say a beneficiary designation review anytime there's any type of life change. And guess what? We've all gone through life changes in 2020. Just the quarantine and the possibility and potential of something like COVID-19 screams that everyone should review their beneficiary designations. But anyone who's had a kid, anyone who's had a death in the family, a divorce, changed jobs, these are things that you need to look at when that occurs. It's also a free, valuable service that you can provide to your clients. We have a beneficiary review checklist that makes it really easy, but we are just looking for mistakes. And the mistakes are a pattern. And once you understand the patterns and what to watch out for, it becomes easier to have this conversation with clients. So here are 6 real easy ones to spot that I think you can immediately interject some value. Also, I think the side effect of this is you need to have a whole look at your client's finances in order to have this conversation. It doesn't do you any good to give you half of their beneficiary designations. You need to see all of them. And that puts you on a very good platform to have a much deeper conversation with the client around all of their financial matters. But a couple things to watch out for, and some of these are very apparent as opposed to others, like blank beneficiary designations. That one's easy. That just goes to your estate, and you're needlessly subjecting the asset to probate. Whereas if you just name someone individually, you're not. Same thing with the estate listed. You're guaranteeing probate. Now, this has bigger ramifications on accounts like annuities, qualified plans, and IRAs, because you're limiting distribution options as far as how long you can string the income tax liability out by doing that. There's been some significant changes in the law in that area, which is something that screams for just an overall estate plan review, because many of our clients may not be aware of it. So just walking them through the Secure Act changes can lead to great opportunities. And it's unfortunate because the Secure Act changes occurred in the beginning of 2020. And what we're finding is clients read about it, they didn't understand it, and they didn't take the next step, because when they were ready to fully understand it, that's when the pandemic hit and they were completely distracted. So many individuals who've done estate planning are likely walking around with expired plans. Long story short, basically what happened is Stretch for most beneficiaries was replaced with a 10-year payout, which means that there's a compressed income tax schedule. So people are going to lose a lot of money to income tax if they don't consider how their beneficiary designations are filled out, specifically with entities like trusts. So identifying that and explaining to the client that you want to pass on as much as you possibly can to your loved ones, maybe supplementing it with life insurance to cover the amount that otherwise would be lost to income tax. So there's a lot of strategies that come out about that, but they may not be aware of it. So a lot of value in discussing that. Out of date beneficiary designations, these are some of the most costly ones, but the easiest to fix. There's a great case in 2005. It's called the pension pickle. I would recommend everyone going to Google, typing in pension pickle, and getting that story, because it just shows for someone who doesn't take action the cost that can occur to their loved ones. In this scenario, it was a lady who had $1 million state pension. So it was a government pension. It was $900,000 by the time she passed away, but she had her uncle, her aunt, and her sister as the original beneficiary designations. When she got married, she never changed it. She didn't put her husband on. And what ended up happening is when she passed away, they honored the original beneficiary designation. The sister got the entire $900,000. The spouse completely left out in the cold. So disinherited for $1 million just because they didn't update the beneficiary designation. And there's tons of stories out there based on second marriages, divorce, and just inaction on the beneficiary designation. That's, again, why it's so important to act when there's a change in your life situation. And sometimes it just takes a reminder from a valued financial professional to do that. There are other nuances. Multiple beneficiaries. Is the company per capita? Are they per stirpes? Does that fit with the estate plan and how they want everything to pass out? That's another area of expertise that many clients may not understand. A big one that we see a lot is juvenile beneficiaries listed. Unfortunately, juvenile beneficiaries, they can't legally inherit something. There has to be an intermediary there. So one thing that we'll see a lot is just a juvenile listed outright on the beneficiary designation form. We saw one case. It was a $16,000 account, not a big account. What ended up happening is they had a juvenile listed. We couldn't pay it out, so they had to go back to family court. Family court in that scenario, $16,000 account cost them $4,000. $4,000 to get letters testamentary saying who the financial guardian was for that minor. That's a quarter of the account. That's a big detail. Easy to avoid, though. The way you avoid it is you list out an UTMA or an UGMA as the beneficiary, or if you have a trust, you can list the trust, or if the firm allows a juvenile beneficiary designation, which allows you to pre-name the person that's of majority age to handle it, to act as the guardian for the minor, that can be an eloquent solution as well. And then the final one is trust listed as beneficiary. Trust listed as beneficiary can be great, but if the only motivating reason for the trust is probate avoidance, that is already accomplished just by naming an individual beneficiary outright. So the trust beneficiary can interject additional income tax, which is unnecessary. And I would say anyone who has a trust listed as beneficiary, asking the client to evaluate if that's the best choice and maybe get another opinion from their attorney for that particular asset, especially with the changes in the rules that have come about, can be very beneficial in passing wealth. Best practices, I think the beneficiary designation review is a really good starting point, and reviewing everything to make sure it's up to date always opens up opportunity. And here we have the resources. The beneficiary review checklist is a great one, very easy to walk through piece with a client. Also, the field guide to estate planning gives you all the nitty gritty and what to watch out for. So we'll shift gears because for many of our clients, they may have a situational quirk that is the most important thing to them in their financial plan. Understanding how to estate plan for control and incapacity is a big one. And as I mentioned, estate planning isn't just something we have to worry about when someone passes away. This is a concern during their life because most people haven't considered incapacity planning, and it can strike at any age. So knowing that someone should do this planning when they're starting a family, when they're making a large purchase, or as they're getting older is a good starting point. So things like stroke, things like Alzheimer's or dementia, which are very common in our situations. Look across the country, the average financial advisor, they have 7 clients in their book of business that have been diagnosed with dementia or Alzheimer's. And the older you get, the more likely it is. 1 out of 3 clients over the age of 85 have a diagnosis of cognitive impairment. So you think about your clients that are over 65, 1 out of 10 of them have cognitive impairment if they look anything like the rest of the country. So this is something you're likely already dealing with. Now, the good thing is you can act while there's capacity. I think there's 3 things really to consider when we're talking about incapacity planning. Get someone else involved. Key there is that's your ticket to the rest of the family. That's the connection to maintain continuity to ensure that your planning spans generations and doesn't die with the original client or when they hit incapacity. So get someone else involved. 2, act while there's capacity. Once you lose capacity, you legally cannot do the planning. Those are the people that want the planning most. Most people want the life insurance when they can't get it. Most people want the planning when it's already occurred. So planning for incapacity starts while that window is open. Once it's closed, there's nothing else you can do. And then understanding the directives and putting them into place is the third takeaway. It's great to talk about all this stuff, but if we don't actually take a motivating step and action to account for it, then we have problems. So actually putting the pen to paper and doing the plan, putting the directives in place is the third and most important takeaway when we talk about incapacity. But many people aren't familiar with why they should even do it. So let's just assume you're walking across the street, you get hit by a bus, and all of a sudden you no longer have legal capacity or the ability to care for your health or your financial well-being. What occurs is you now have to go to court. There's a hearing held. And that hearing is to determine whether or not you're incapacitated. In a lot of these circumstances, this is very contentious because a lot of people don't want to admit that they don't have the capacity to run their own lives anymore. It's literally taking away the liberty and independence of living on your own, taking care of yourself from a health standpoint and taking care of your finances. So sometimes this is a family member stepping forward and saying, Mom, Dad, they can't take care of themselves anymore. We have to have someone step in. So the court will then appoint a guardian or a conservator. And that person now is responsible for running that individual's life. That individual is literally a ward of the state, and that person is their legal representative. They ongoing have to go back to the court to make directives. But what we find a lot of times is they have their own financial professionals that they work with. So all the planning that we've done generally goes out the window, or it's very difficult for us. Best case scenario, we have to continue to go on and get documentation from them on an ongoing basis, so it can be a hassle. Really easy to avoid this, though. If you have some foresight and you can do some planning, just having the right POAs can make a big difference. And POAs, unfortunately, there's too many types of them, so almost its own level of expertise is required here. We have a great piece, though, called Guide to Guardianship, Powers of Attorney, and Advanced Healthcare Directives. This spells out everything. It's a client-approved piece, but it is Baskin-Robbins with 31 different flavors of POAs, and they all do something a little bit different. And one little quirk in your POA makes a huge difference on how it's executed. So understanding the differences between these is a lot of the art in the planning. Additionally, there's other types of directives that become pertinent in certain circumstances. So living wills, healthcare proxies, DNRs, these are all important for the qualitative aspects of what happens to you in a health situation. But here, I think the best approach is to pick an age or understand that you need to have this conversation at different life events. So a client starts a family. They should be having the conversation about POAs and how to arrange their affairs. Or your client hits a specific age, 60 or 65. What should occur is they get something like that Guide to Guardianship, Powers of Attorney, and Advanced Healthcare Directives to tell them exactly what they should consider to put in place to safeguard themselves from the unknown. And then it's a matter of making a connection with that person. And actually, FINRA made this a requirement back in 2018 as part of the account opening process. So on the account statement, or when you open an account, there's a trusted contact person that you're supposed to put if they're over a certain age or if they meet specified criteria. That is one of the best things to make a connection with probably the most responsible person in the family, because that person likely is the executor. That person is likely the trustee. That person is the one that shepherds the family through all financial affairs. So that is absolutely the person that you want to have a relationship with. This is a great opportunity to get that. They're also likely the POA. So having that POA in the relationship with it makes your life a lot easier, but also allows you the opportunity to demonstrate your value to that family. Understanding the review and providing that documentation. So again, I think bottom line here, pick an age, pick benchmarks, make sure they get that documentation when they hit those, because it is something where we can guide a horse to water. They're not necessarily going to drink, and you can actually even do the planning right and have it blow up in your face. I can recall one situation in Texas where it was a couple who became incapacitated and they had the POAs in place. Problem was they never talked to their kids, and their kids were deathly afraid of anything financially oriented. So they recused themselves as POAs when the time came, and they still ended up in a conservatorship situation. And that's where we're the intermediary. That's where we can help with the communication with the family and what needs to occur. That communication is key. A lot of beneficiaries don't know they're the beneficiaries, and sometimes it even ends up in state unclaimed asset funds. It's why those accounts are in the billions. It's just the failure of communication while the individual is alive. So we have an opportunity to really help clients in that area. But it's not just that. You pick the wrong POA, and that can be a disaster. You pick the wrong beneficiary, and that can be a disaster, because spendthrift beneficiaries can rifle through an inheritance faster than anyone. So identifying the necessary controls to make sure the legacy lasts as long as the individual wants it to. And here we have a lot of different instruments to do that. I think some we've already touched on, but they're not built equal as far as how they're executed. So wills is a good example here. Wills can be used to control an inheritance. However, guess what you're subjecting the asset to? You're subjecting it to probate and all the disadvantages that come along with it. Also, you have to keep the estate open. That's not convenient. In fact, the goal for most estates is to close as quickly as you possibly can, because they're taxed differently. There's attorney's fees and expenses that can occur during that period. So the end goal for most estates and probate is to get it closed. So the will can be a poor instrument if you're trying to provide ongoing control in an estate plan. Also, restricted beneficiaries can be great here. And I think one of the issues we see a lot with control is I don't have millions of dollars to set up a trust. My estate planning needs aren't the same as a celebrity's. I don't want to have to deal with this. So what avenues are available to me? Restricted beneficiaries can be a great avenue. And these are beneficiary designations that have restrictions that come into effect upon death. Now here, it's not perfect. There are disadvantages and there's advantages. So here the disadvantages would be they're not all built equal. There's different capabilities built into restricted beneficiaries. Also, they're only limited to that asset, and it's only as good as the custodian. One tip is you want it to be contractual. If it's not contractual and it's just something that's, say, like a form, that's not as solid and concrete as something that's based in contract law. Contract law, if it's contractual, makes sure that both parties have to acquiesce to the wills as put forth. But it is easy to set up. It's pretty easy to understand. It can be something that resonates quite deeply with many clients. Trusts are the Cadillac of control when we talk about this. You can do most everything that you want as far as a control standpoint. Disadvantage is you have to set it up, so there's expenses with that. You have ongoing administrative expenses. You have a trustee that you're probably going to have to rely on, or you're going to have to farm that out to a corporate trustee. But trusts tend to be the currency that attorneys love to deal in. So if you're in the estate planning world, you're bound to run into trust because of the latitude and what they allow the grantor to accomplish. But they're not all the same. There's different types of trusts, and this can get very confusing. Clients don't understand that revocable trusts are completely different from irrevocable trusts. In fact, revocable trusts, by and large, are set up just for probate avoidance. So some people will go out and spend thousands of dollars to set one of these trusts up, not realizing that something as simple as a properly filled out beneficiary designation will accomplish the same thing. So living trusts, way to identify them. Social Security number is going to be used. 99% of the time, you're going to see the Social Security number used, and that means that that asset is still taxed back to the grantor. It's still owned by the grantor. They have possession of it, and the grantor can take it back at any point in time. But again, probate avoidance is the general reason people set these up. Also, they can be great for pre-planning, because when a revocable trust ends, which occurs upon the death or disability of somebody, they will become irrevocable trusts. And irrevocable trusts are the ones that are separate tax-paying entities. And this is where you see a flourish of different estate planning objectives come to the use of this one specific type of instrument. So very easy way to identify them. You're going to see a tax identification number on that trust. Now, these trusts are put at a disadvantage. These are taxed differently than other tax-paying entities. They have a very compressed income tax rate schedule. This is intentional because in the 90s, during the Clinton administration, there was a strategy where you would take your assets and you would divvy them up to different trusts, which are separate tax-paying entities, and depress your income by separating your income and spreading it out. Now, what they did to avoid that is they put compressed income tax rate brackets on irrevocable trusts. So you and I, if we're married filing jointly, when we come to file our return in April, we're not paying the 37% income tax rate until we hit $622,050 of income. So $622,000. Now you contrast that to a trust. A trust pays that same 37% income tax rate at $13,050 of income. Everything over that is 37%. So anything that's spitting off income, recognizable income tax within a trust, is something you want to avoid because you're going to lose a lot of that asset. So to avoid that, we can look at investments within trusts. And this is where there's a great opportunity. If you identify funded irrevocable trusts and you look at how they're invested, just shifting things around can minimize the income tax that's attributed to that trust. So here we see things like growth stocks, annuities are used quite frequently, and life insurance. Cash value life insurance is the creme de la creme of investments within many trusts, so long as it allows it, because the death benefit's income tax free and it grows tax deferred during the life of that individual as long as that trust is funded. So great opportunities there, and many people don't want to deal with that income tax liability, but they set it up for a lot of different reasons. This is where the situational part comes from. I think what's great about the guide to estate planning that we have in association with this is it goes through all these different trusts and why people set them up and the different rationales for the planning behind them. So an example, Q-tip trusts, special needs trusts. Q-tip trusts for second marriages. Special needs trusts are for special needs individuals who are claiming benefits that are asset or income constrained. So these can be great conversations to have. And again, the investment within this and the estate planning that comes down with it is the ultimate goal. But having the right resources to have these conversations is extremely important, and understanding the overall estate planning implications can, again, create tremendous value in demonstrating what you bring to the table for those clients. And it's connecting with what they really care about. The other side is high net worth individuals. And this is an area where a little bit of expertise can go a long way because there's only so many ways to plan this out. But they're going to be more prone to tax issues. So there's more than one type of tax issue that we run across in estate planning. It's not just the income tax, but when you get to a large enough net worth, you're going to have estate tax issues, you're going to have generation skipping transfer tax issues, and you're going to have gift tax issues if you're making gifts. The problem that we're running in right now is we've seen a lot of inflation in our estate tax exclusion. I already touched on it. 2003, it was $1 million exclusion. We saw it go to 1.5. We saw it go to 2. We saw it go to 3.5. And then 2010 hit. 2010, George Steinbrenner passed away. His estate saved $300 to $400 million because he passed away in 2010 and not 2009. And this was something that was never supposed to happen. We never were supposed to see the repeal of the estate tax. Well, it happened. There was a little bit of a fervor about it. It came back at $5 million the next year. And subsequently, 2018, it went up to $11 million indexed for inflation. We stand at $11.7 million exclusion. So for a husband and a wife, you need $23.4 million before you pay a cent of estate tax. Now, the future is where the uncertainty comes from, because we know with the Tax Cut and Jobs Act, which is known as the Trump tax cuts, we know that in 2026, that's going to sunset. And with the new administration, the Biden administration, and the legislature controlled by the Democratic Party, there's a big question as to what the future of our $11.7 million estate tax exclusion is. So there are some thoughts. And depending on who you read, there are some really inflammatory thoughts. There are some people that feel that it might be retroactive this year. Depending on who you read, it might not even be anything until you have to worry about in 2026. But best case scenario, nothing happens. By 2026, we're supposed to see the exclusion go from 11.7 million down to 5. So that's if nothing occurs. Now, we do know what the Biden administration said on the campaign trail and what they felt was their desire for the estate tax exclusion. And what they said is they said we want either 3.5 million or a $5 million exclusion. So for 11.7 down to 5, we're missing out on $6 million of exclusion. So far in 2021, what we've been having conversations about, and this has been without a doubt, with a bullet, the number one conversation we're seeing from high net worth clients is considering gifting. Gifting strategies this year are extremely prevalent. So we're talking about really high net worth individuals scared of losing that $6 million because you have the option. When we talk about our estate tax, you can either pay it at death or you can pay it forward and do it during life through a gift tax. But they're giving the money to trusts. They're not giving it directly to their kids who they don't necessarily trust yet. They want some strings attached. So one of the strategies is let's lock in the $11.7 million and give it to an irrevocable trust. We already covered the income taxation of trusts. You're swapping an estate tax problem, which is a maybe, for a current income tax problem. So you have to consider that dynamic. And if they do end up going that route because of the uncertainty, you have an opportunity to have a discussion about how to do it smartly, how to implement strategies to minimize the income tax within those trusts. And having the right resources to bear, I think, makes a huge difference in the outcome of that conversation. Also, another one that they talked about, and I think this would be probably one of the bigger sales strategies around life insurance, is the step up in cost basis. They said during the campaign that they were considering getting rid of the step up in cost basis if they were elected into office. Now, this could be very problematic, and we don't know what the details would look like or even if it would come about. But consider maybe your client who's property rich but cash poor. So maybe you have a large farm and you pass away. We don't know what that cost basis is. If it doesn't get a step up in cost basis, not only could you owe estate tax on it, but you would also have an income tax problem for the beneficiaries. Having the necessary liquidity to cover those areas for property owners likely is going to be an issue going forward. And life insurance is the only vehicle that I know that's going to be able to do that feasibly. So step up in cost basis, I think you have to connect the dots, and insulating those clients from that inevitability or possibility becomes part of the planning strategy. Likewise, I'd say the same thing when we talk about income in respect of decedent, which is just a fancy way of saying taxable income to a beneficiary. So that would be IRAs, that'd be qualified plans, and that's the Secure Act conversation we already discussed. Having life insurance to cover the compressed 10-year period as opposed to the stretch that we used to get. Estate tax, again, 11.7 plus portability, probably not going to be an issue right now, but if it goes down to 5, goes down to 3.5, that's going to impact a lot more people. So having those conversations today as opposed to 5 years from now, when we may not be able to do anything about it, is the goal. And gift tax allows us to do that.
Hey, Ryan, I wanted to ask a quick question there. When we talk about the estate tax, I know for a lot of folks who are on in WFG, we do a large amount of foreign national business, which is usually a lot of our larger cases. But I always think it's an opportunity to talk about the differences in estate tax and how small the exemption is for those cases or clients relative to the domestic cases. So huge opportunity there as well.
Massive opportunity. And I think anyone who's a foreign national or a non-resident alien in that scenario, you look at the exclusion amount. So I've mentioned 11.7 million probably 20 times already, but you look at the exclusion amount for a foreign national, it's 60,000. So you're exposed currently to transfer tax issues if you have that scenario. So making sure there's proper life insurance to cover that, because you're going to need it when we talk about a tax of that severity, is the end goal. And here I think the expertise again makes all the difference in having resources. Transamerica specifically has a slew of resources behind foreign national and international planning. So if you run into those scenarios and you identify that, and that's a very easy one to identify, we can help. We have generations of experience at the company, a lot of intellectual capital in this area. It would be what I would call one of our major bright spots. So that's a huge aspect of insurance planning. And I'm glad you brought that up, Victor, because that's a great opportunity. Also, the income tax side, just running through this really quickly, Roth conversions, that can be a major component of the estate plan, because RMDs drag on how much you're passing. Doing Roth conversions and making sure there's funding there to pay the tax liability and the planning behind it. Again, making sure we leverage the longest periods of time to stretch out qualified accounts, and then trust planning and life insurance trusts for many. That's been a big conversation, and charitable giving is another one. I would say gift trusts, charitable giving in tandem have been two of the biggest strategies we've talked about so far this year, at least what we've seen where the anxiety for the uber affluent is. So not overlooking those scenarios. And I think this year is a great opportunity for it. And then reducing through annual gifts is still a great possibility. $15,000 per year per beneficiary. You spread that out among a lot of people, that can definitely reduce a taxable estate, in addition to making gifts now and freezing the growth out. But as you see, high net worth individuals, we're at crossroads, and making sure you have those conversations now to when the changes do occur. And when they do occur, I think staying abreast of them. And we'll do that. We'll definitely have resources for you in this area when we do see a change, because I think it's one of those times where we see pivot points in our industry. And in those pivot points and in that change comes the opportunities to make a massive impact, not only to your business, but really to your clients and their families. And that's the value that we bring to the table. And I think it's really a sacred thing for us to be able to do that properly for our clients. And then, of course, having all the other things with estate planning. And that field guide to estate planning, it gives you the comprehensive list. So from POAs down to trusts and wills, that can all help have this conversation. And that's really what we're here to do. We're here to be a resource for you. So if you're ever looking for information in this area, there are 7 of us out in Denver, Colorado. Actually across the country. We got someone in Texas, we got 2 people in Florida, and the rest of us are out in Colorado. So we're here to provide this expertise. We develop the tools and resources really to help make this easy for you, because this is an intimidating area. You talk about this enough and you get an estate planning attorney coming at you, having the ammunition in the backup helps innumerably. So with that, I want to thank Victor. I'm really excited to be working with everybody, and I'll pass it to you for some closing thoughts.
Thank you so much. Well, we're right up against it, a minute left. I'll just ask, what did I tell you guys? Lots of information.